Welcome to part one of this series of videos, which are all focused on the life cycle of an early stage tax dispute. Part one deals with informal inquiries. And the first slide here is an example case study of a potential illustrative timeline of an early stage dispute. And as you'll see, our case study starts with informal inquiries from HMRC. Now, what this means is that a statutory inquiry is not yet open into a particular tax return. And so this email that we've mocked up here on the slide is the first contact from HMRC that might suggest that they are looking into the taxpayer's return for a particular year. As shown on the slide, the informal queries are likely to be addressed to the accountants who deal with tax compliance for the taxpayer and have provided a Form 64/8 to act as their agent. But this email also may be sent directly to the taxpayer. And there are a couple of important points that I wanted to draw out in relation to these types of informal requests. Firstly, it is within HMRC's powers to assess tax on the basis of voluntary disclosures in the course of informal investigations. And this was confirmed in a recent case called JJ Management Consulting LLP. And that case held that HMRC's function is to collect the correct amount of tax, and that Section 9, subsection 1 of the Commissioners for Revenue and Customs Act 2005 empowers HMRC to do anything which is necessary, expedient, incidental, or conducive to the exercise of that function. HMRC therefore have wide discretion as to the best means of collecting tax, and may do so based on the discovery made in the course of asking these informal questions of the taxpayer when no official inquiry has yet been raised. As is discussed in the next video, part 2 of this series, HMRC are subject to a time limit of 12 months for opening inquiry into a taxpayer's tax return following it being submitted to HMRC. Such informal investigations are not subject to the same time limitation placed on HMRC's powers. It follows then that there is no closure notice procedure, as that only applies where investigations have been conducted within the statutory framework. The Court of Appeal in JJ Management accepted that an informal investigation is potentially subject to court oversight via judicial review, but considered that, in practice, it would take a wholly exceptional case on its legal merits to justify judicial review of a discretionary decision by HMRC to conduct an informal investigation of the kind conducted in that case. Secondly, there are likely to be other legal implications of disclosing certain information on a voluntary basis. A quick-fire, not well thought-through response could easily breach terms of confidentiality or GDPR that the taxpayer may be subject to, perhaps in relation to its shareholders, employees, or another third party. The third point I wanted to bring out is that it is worth getting lawyers involved early because lawyers have legal professional privilege. The UK Supreme Court decision in a case called Prudential plc and Prudential Gibraltar Limited has confirmed that legal professional privilege only covers communications with lawyers and does not include communications with accountants and other non-lawyer tax advisors. Further, a professional accountant may not act as an advocate on behalf of an audit client in litigation or disputes. So as these informal inquiries become clearly a dispute or something that could reasonably lead to litigation, there will come a point at which the accountants have to step down and the lawyers will be required to take over the dispute, as it were. In our experience, involving lawyers early in the dispute alongside and in collaboration with the accountants who may be the long-standing tax agents of the taxpayer works very well. In summary, informal queries from HMRC are to be considered carefully and responded to with caution, taking into account confidentiality and GDPR obligations, as well as being aware that voluntary disclosures made during this period can have significant consequences in the course of a dispute with HMRC. The outcome of JJ Management may encourage HMRC to increasingly utilise this informal method of investigation where its powers are less fettered by statute.